Ibriam Kendi is often quoted as saying the only remedy to past discrimination is present discrimination. Is that true? Above the main entrance to the Supreme Court is a promise chiseled in the marble facade: equal justice under law. How can we have equal justice under law if one side is always discriminating against another? Enter the case of Ames versus Ohio Department of Youth Services, where Marlene Haynes claimed she was discriminated in her job because of her sexual orientation. What makes this case unique is Ms. Ames is heterosexual, and the Sixth Circuit claimed that meant she had a higher burden of proof than a homosexual. So we'll discuss this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your and generation be free. I'm glad you could join me today. This case caught my attention because, to my knowledge, this is the first quote-unquote reverse discrimination case I've seen involving sexual orientation. It caught my attention, and I've been following it. Now, this is the oral arguments, and that's what we're going to look at today. I'll look at the decision once it comes out, but it's a very important case, and the oral argument really is important. Now, if you want to find out more, I've written an entire article about this. You can find it at the website, constitutionstudy.com. I'll talk more about the website and some other ways you can support the work that we're doing here at the end of the episode. But for now, let's take a look at this case, Ames versus Ohio. We start with oral arguments from Mr. Zhao Wang, attorney for Ms. Ames. Mr. Wang begins by describing the situation that led to the lawsuit.
Mr. Chief Justice, and may it please the court. Marlene Ames has worked for the Ohio Department of Youth Services for over 2 decades, and in 2018, her year-end performance review described her as being very competent in her role, a pleasure to have on the team, and always willing to assist others. But in 2019, she experienced 2 adverse employment actions. First, she sought a promotion to bureau chief, for which she was qualified, for which she applied, and for which she interviewed. But neither she nor the 2 other heterosexual employees who applied and interviewed got the job. Instead, the job was held open for 8 months before going to a gay employee who neither applied nor interviewed for the position. And second, Ms. Ames lost the job that she was in, and she lost it and was replaced by a separate gay employee who also did not apply or interview for the position.
The situation described by Mr. Wang certainly does seem to show discrimination. First, 3 heterosexual applicants for a job are denied. Then the job is left open for months until a homosexual employee was given the job, even though they never applied for nor interviewed for the position. Then Ms. Ames lost a job for which she had been given excellent performance reviews, only to have the vacancy filled by yet another homosexual person who neither applied nor was interviewed for the position. Seems pretty cut and dried, both to me and to the Sixth Circuit Court of Appeals.
Based on these facts, the Sixth Circuit held that Ms. Ames had satisfied the usual requirements for stating a prima facie case of discrimination under Title VII, but she could not proceed because of the background circumstances rule, which the Sixth Circuit described as an additional showing unique to majority group plaintiffs.
Wait. Ms. Ames stated a prima facie case of discrimination, a fact presumed to be true unless disproved. But because she wasn't a minority, she needed to prove more?
The narrow question before the court today is whether this judge-made rule is consistent with Title VII, and we submit that it is not. It's not because this court has said that Title VII aims to eradicate all discrimination in the workplace. But the background circumstances rule doesn't do that. It doesn't eradicate discrimination. It instructs courts to practice it by sorting individuals into majority and minority groups based on their race, their sex, or their protected characteristic, and applying a categorical evidentiary presumption, not in favor of, but against the non-moving party, based solely on their being in a majority group, however you define it.
Title VII was created to get rid of discrimination. Yet this background circumstances rule, something made up by courts and is not law, actually tells courts to discriminate Again, this is not based on a law passed by Congress, but by a rule established by one or more judges in violation of the law.
But that's not consistent with the statute that tells us that we are supposed to protect all individuals from individual discrimination based on the individual case. And it's not consistent with McDonald versus Santa Fe Trail, where this court says that all individuals, whether in majority or minority groups, are protected by Title VII under the same terms and the same standards. For these reasons, we urge the court to reverse the judgment of the Sixth Circuit. I welcome the court's questions.
It took no time at all for the justices to start their questions. Justice Thomas started off with a question about precedent.
What do you do with respondents' argument that this is merely an application of our precedents?
I don't think it is an application of this court's precedents, Your Honor. And Justice Thomas, it's because this court's precedents in McDonald Douglas lays out a framework, and then McDonald versus Santa Fe Trail says they apply to the same terms and same standards. But the background circumstances rule isn't the same term. It's not the same standard. The Sixth Circuit says it's an additional burden. And in prior cases, it says it's a difficult and more demanding burden on majority group plaintiffs. So I don't think it's consistent with this court's precedents.
So Mr. Wang doesn't think the Sixth Circuit decision followed Supreme Court precedent by adding the greater burden to majority group plaintiffs. Next, Chief Justice Roberts puts the question in another context.
What if you have a situation where, say, 60 employees in the company, say, a half dozen African Americans, an African American applies for a job, there's an opening, he doesn't get it, remains open for, a couple of months. Does that satisfy the prima facie case? He said it was because of discrimination.
Assuming that they are qualified and yes.
Okay. Now, I'm sorry. That's a yes?
Yes, that is true.
Okay. Now let's say it's the same thing, but the applicant is white. Exactly the same facts. And she says, I lost the job because of discrimination on the basis of race. Does that state a prima facie case?
I think it states a prima facie case, but I think it goes, and perhaps, Your Honor, it goes to the idea of getting employers to come forward with an explanation and then providing sort of a legitimate non-discriminatory reason, which I don't think is a high burden at all. I think as Reeves, as Burdine, as Fernco made clear, they just have to provide some sort of legitimate non-discriminatory reason to answer or to rebut the prima facie case.
So what appears to be an obvious case of discrimination can be stopped if the employer simply shows there was a non-discriminatory reason for the action. Now, Justice Barrett dealt with a claim that, should the court agree with the petitioner, it would open almost any case where someone did not get a job to claims of discrimination.
Counsel, what do you have to say to the department's contention that this is just going to throw the door wide open to Title VII suits? Because now everybody can say, hey, this was discrimination on the basis of race, gender, et cetera.
Well, I don't think that contention is well taken, Justice Barrett, and for two reasons. The first is this is an evidentiary question that arises at summary judgment. So they've already gotten past a discussion with the EEOC, plausibility under Iqbal and Twombly, a motion to dismiss. So I think if there were a floodgate issue, that would be sort of more on the pleading standards. I think the second point is merely sort of an empirical question. And as we lay out, and as Judge Kethledge lays out in his concurrence, about more than half the circuits don't apply the background circumstances rule. We don't see those circuits having some sort of flood of litigation. I don't think there's a huge delta between those circuits that apply it and those circuits that don't apply it, which I think goes to the narrow question that's before the court today.
Other circuits do not use the background circumstances rule, and they do not have a problem. Neither does the EEOC. So there's no reason to believe removing the rule from all circuits would make much of a difference. Now, Justice Kavanaugh wanted to know what Mr. Wang wanted from the court.
So all you want for this case is a really short opinion that says discrimination on the basis of sexual orientation, whether it's because you're gay or because you're straight, is prohibited and the rules are the same whichever way that goes.
That's right, Your Honor. And
That's all we need to say, right?
I think that would be something. Well, I think you'd also have to say reverse or vacate and remand. I want to look out for my client here a little bit, but certainly as to the reasoning, yes, I entirely agree. I think that this is a narrow question, and it's a question of is there an added burden? And if the answer, I think, under McDonald and under Title VII's text is no, then this goes back to the lower courts to resolve.
A simple ask of the court. Make sure that every case before the court is treated the same, regardless of whether they are part of some protected class or not. Ms. Robertson, assistant to the Solicitor General of the United States, offered her arguments in support of vacating the lower court decision.
Mr. Chief Justice, and may it please the Court, the Court of Appeals applied a different and more difficult standard to petitioner because it considered her a member of the majority. But Title VII draws no distinctions between plaintiffs based on their race, religion, sex, or other protected characteristic. That alone is reason to vacate the decision below, but the Sixth Circuit's test would have been wrong if applied even-handedly.
Ms. Robertson gets right to the point. While the Court of Appeals applied a standard, it was not based on the law, but on their own apparent desire to discriminate against what they see as the majority. That alone should be enough to vacate their decision. But Ms. Robertson goes further, claiming that even if the court had applied the test even-handedly, it would have been wrong.
The court required evidence, reason to suspect an employer usually discriminates against a group, that the statute does not, and it required more evidence to make out a prima facie case than this court has held as necessary, including in McDonnell Douglas itself. That heightened standard risks screening out cases with merit and complicates litigation by focusing on whether to shift a burden of production that Ohio had already met in this case. The court should vacate and remand for the Court of Appeals to apply the proper standards in the first instance, including to consider Ohio's alternative arguments for why summary judgment might still be proper. I welcome the court's questions.
The goal of the court should not be to screen out cases which may have merit, especially because of some protected class. Now, in response to a question from Justice Jackson, Ms. Robertson brings up an interesting point. Does a lack of evidence of discrimination against a group mean that there cannot be discrimination against an individual?
So what the Sixth Circuit did here, for instance, by asking for reason to think that an employer usually discriminates against a group, requires evidence that a plaintiff wouldn't need to establish liability under the statute, because, of course, even if an employer generally treats a group well, if a plaintiff has evidence that the employer discriminated against her, she should be able to proceed.
Later, in response to a question from Justice Alito, Ms. Robertson pointed out how she believes the Sixth Circuit got it wrong.
I think it's important to distinguish between two ways that a court might take race into account. The first is the way that the Sixth Circuit did, which is tell me your race and I will tell you how much evidence you need to produce, or I'll apply in a different standard. That would be wrong at any stage in the proceeding.
Okay.
That's not to say that race is irrelevant in a race discrimination case or that sex is irrelevant in a sex discrimination case. Second, courts can consider a plaintiff's identity to help them draw inferences from the evidence in the record. So comments that look neutral in a vacuum might take on a different valence when directed at a certain group.
In other words, it's not that race doesn't matter in discrimination cases, but that your burden of proof should not be based on race, sex, or any other grouping. The final attorney to speak was Mr. T. Elliott Gazer, Solicitor General for the state of Ohio. Now, as you might expect, Ohio sees the facts of the case differently.
Mr. Chief Justice, and may it please the court, Ohio agrees it is wrong to hold some litigants to a higher standard because of their protected characteristics. But that is not what happened in this case. When Governor DeWine took office in January 2019 and appointed a new cabinet-level director of the Ohio Department of Youth Services, the state's juvenile correction system, petitioner was an unclassified civil servant, effectively an at-will political appointee. She claims the department took 2 adverse actions against her in the first 5 months of the administration, denying her a promotion and demoting her because of her sexual orientation. But after discovery, she could not establish that anybody was motivated by sexual orientation or even knew her sexual orientation, nor the orientation of the unclassified political appointees, Ms. Frierson and Mr. Stoj-Sevljevic, that she points to as comparators.
Wait a second. Doesn't the premise of a majority group include the assumption of membership in that group unless there's evidence to the contrary? Wouldn't it be the assumption that Ms. Ames, Ms. Frierson, and Mr. Stoj-Sevljevic are heterosexual?
In other words, she failed to make out a prima facie case under the first step of McDonnell-Douglas that should apply to every Title VII plaintiff. She didn't provide evidence that, to quote Fernco, if otherwise unexplained, raises an inference of discrimination.
I suppose that would be true if the people who were chosen to fill these two positions had applied for the job like the others, had interviewed for the job like the others, and were at least as qualified as the others. Then again, since neither person applied for the job, why were they chosen? Now, one distinguishing factor is their sexual orientation. And since the fundamental assumption of majority groups is that most people are part of them, that seems to be a prima facie case to me.
Whether that evidentiary standard is framed as background circumstances, as in Parker, or circumstances which give rise to an inference of unlawful discrimination, as in Burdine, this court has said a prima facie case under Title VII must be complete enough for the court to enter judgment for the plaintiff before the burden shifts to the employer. Because the best reading of the Sixth Circuit judgment applies that standard, this court should affirm.
Remember this statement because it will become very important during the justice's questioning.
If this court nevertheless holds petitioner made out a prima facie case on these facts, then McDonnell-Douglas has effectively two prongs, and the court will have made Title VII that unusual statute that presumes liability for employers and swallows what remains of at-will employment. I welcome the court's questions.
It seems to be the logic of Mr. Gaser's argument is that we got the answer we want, so please don't overturn it. During questioning, I think Mr. Gaser really stepped in it when he answered a question from Justice Kagan.
Mr. Geiser, I mean, you can say, well, there's language. I mean, I think that that's the absolutely critical language in this opinion. Because Ames is heterosexual, she must make a showing in addition to the usual ones for establishing a prima facie case. And then it says, Ames's prima facie case would have been easy to make had she belonged to the relevant minority group, here gay people. So, I mean, this is what the court did.
The Sixth Circuit clearly stated that Ms. Ames' case would have been easily made if she were part of the relevant minority class. Meaning, because she was not gay, she had a higher burden to prove her case had merit. This is where Mr. Gaser had to backpedal.
Well, and we can't retreat from what the court here said, but we think the best way to construe that language is consistent. But nevertheless, I think
the best way to construe that language is as the language says.
Well, Justice Kagan, yes, the court said what it said. The important point is the prima facie step that this court has laid out needs to be complete enough before the employer has any burden under Title VII to show an inference of discrimination.
So according to Mr. Gaser, the question before the court, if the Sixth Circuit erred, doesn't matter. When the Sixth Circuit denied to review the case, even though they admitted Ms. Ames had made her prima facie case because she was a heterosexual, is not the point. So did she make the prima facie case? The court clearly stated she did.
You agree that those passages are wrong?
We're not defending the exact language there. This per curiam, we asked for...
So let me get this right. Ohio is defending the case, but not the language the court used in the case. I've heard this before from my own lips, but this is a different situation entirely.
The exact language, or you're defending something like that language? I mean, it's a little bit of a peculiar situation, isn't it? Because this is what the court said, and you're up here, and I don't know exactly what to make of this. Do you think that that's right, or do you think that it's wrong?
I think the idea that you hold people to different standards because of their protected characteristics is wrong. And if there's any upshot from this case, let reverse discrimination completely fall out of the federal reporter.
If the state of Ohio believes reverse discrimination is wrong, why are they fighting to prevent a case about reverse discrimination from continuing? I agree, this argument just doesn't make sense.
I guess my reaction to a lot of what you're saying is this. You say you agree with your friends on the question that we took this case to decide. The question presented is whether a majority group plaintiff has to show something more than a minority group plaintiff. Here, whether a straight person has to show more than a gay person. Everybody over here says no. You say no, too. That was the question that we took the case to decide. And now you're asking us to opine on various other aspects of how the McDonnell-Douglas test works, what we should think of the first step as doing, then what we should think of the second and third steps as doing, that are, really not intertwined at all with that question. Whatever McDonnell Douglas does, it does for majority group plaintiffs and minority group plaintiffs alike, is all that we have to say. Why shouldn't we approach the case in that way?
And attorneys wonder why people hate them. Here you have a simple question presented to the court. A question where all the parties to the case agree the answer should be no, but Mr. Gazer, representing the state of Ohio, doesn't want it reversed. This idea of the ends justify the means is what so many Americans find disgusting about the legal profession.
Well, I think there are two responses to that, Justice Kagan. First of all, while we all agree that everyone should be treated equally, we don't agree about what that prima facie step actually looks like.
Yes, I know. That's exactly what my point is. But that's orthogonal to the question we took. So, I mean, why would we use this case, which is about whether a majority group plaintiff has an extra burden, to opine on a range of things that have nothing to do with that question?
Well, so what the Sixth Circuit did here, this is my second reason, Justice Kagan, if the first one doesn't satisfy you, is exactly what we think every court should do. Ask for enough evidence to raise an inference of discrimination. And simply going through those four prongs, copy-pasting McDonnell Douglas with subbing out racial minority for any particular protected group doesn't do that. It doesn't satisfy what this court said in Reeves and Burdine in footnote 6 and 7. And so our thought is the court should still affirm, because what the Sixth Circuit's judgment did here is what we ask every court to do at the first step of McDonnell Douglas, even if we agree that saying that an additional burden is a mischaracterization of what this court has said in the past.
In short, we agree that the circuit court should not have dropped the case because it is unfair, but the state of Ohio doesn't want the Supreme Court to reverse because Ms. Ames hasn't made the case that she has not had a chance to argue yet. I'm sorry, but I find Mr. Gage's argument disgusting. Since Mr. Wang represents the petitioner and therefore argued first, he gets a chance to rebut the other arguments.
Thank you, Mr. Chief Justice. I'll be very brief. I just want to conclude, I think, with several members of the court have talked about this theme, and it's actually something that my co-counsel, Mr. Gilbert, and I talked about when entering the court this morning, which is, I think, what this case is all about. And those are the four words on the side of this building: equal justice under law. Equal justice under law.
Equal justice under law. Is that too much to ask from the Supreme Court? Was it too much to ask the circuit court or even the district court? If everyone agrees that should be the goal, then why is the state of Ohio fighting so hard against it?
Now, I know that sometimes we don't fulfill that promise. I understand that. But at the heart of this case, at bottom, all Ms. Ames is asking for is equal justice under law. Not more justice, but certainly not less. And certainly not less because of the color of her skin or because of her sex or because of her religion. We're simply asking for equal justice under law because I think that's what Title VII says, and I think that's consistent with what this court has held in numerous cases, and it's consistent with Congress's intent in passing a civil rights law to protect the civil rights of all Americans.
And those words on the facade of the Supreme Court state, equal justice under law. Is that too much to ask? Is it too much to be judged on the merits of the case rather than the color of a person's skin or their sexual preferences? I know it's the job of an attorney to represent his client to the best of his abilities, which makes me wonder why someone like T. Elliott Gazer could argue such a case. How can you claim we all agree that everyone should be treated equally, yet oppose a decision to treat all people equally? If, as Mr. Gazer claimed in court, Ms. Ames didn't present a prima facie case, a claim flatly denied by the Sixth Circuit Court of Appeals, then let her have her day in court and show she's wrong. Personally, I don't know how someone could look at the facts of this case and not see the strong possibility, even the prima facie case, of discrimination. Then again, I'm not an attorney, and I've never played one on TV. And even if I had, I hope I would never sell my soul to argue such a case of injustice. So as I've said, I've been waiting for a case like this, a case of reverse discrimination based on the homosexual lifestyle. And I'm very curious for the decision of the court, not just for their answer, but how they got to that answer. Based on a lot of the oral arguments, I might lean a little towards Ms. Ames, but it's never good to try and read the tea leaves at the Supreme Court. Based on their oral arguments, they're trying to poke holes in arguments. It doesn't always show where they sit, where they're leaning towards one way or the other. And then, of course, you have all the discussion and the debate, and we have to wait and see. This is a big case, which means you probably won't hear about it until the end of June, which is the end of the session for this court. But I think it's important to look at it and say, if everybody should be treated equal, why don't we treat everyone equal? I mean, it seems to be a simple question. If we think everyone should be treated equally, why don't we treat everyone equally? Which, of course, brings the question, if you aren't treating people equally, do you really believe they should be treated equally? I hope you stick along. I'm going to follow this case, and I'll report on it once the decision comes in. That should be, again, an interesting analysis. Now, if you want to find out more, again, this case or any other case that I cover, we'll go to constitutionstudy.com and check it out. I post all of my content there with all the links back to my original sources so that you can double-check my work. I've also got mailing lists for news items and radio shows that I post. There's a lot of information there. Please check it out. Now, I also hope you'll check out The Miracle of Americas. This course I found very interesting. It covers a time most people don't, from the Pilgrims through the drafting of the Constitution. It helps explain why the Declaration of Independence and the Constitution were written the way they were, why they include the language that they do. And I found it very interesting. So I made a deal with the owner and said, hey, can I get my audience a free lesson, something to try before they buy? And they agreed. Go to constitutionstudy.com/1776 study guide. That's the numerals, 1776 study guide. You'll be taken to a custom landing page just for my listeners, and you can read up about the course, read up about the teacher, but most of all, you can enroll for your free lesson on God's natural law. You get the downloadable study guide, an hour of video or an hour of audio, all absolutely free, but only if you go to constitutionstudy.com/1776 study guide. And if you like the course, you can get the whole thing for just $17.76, which seems to be a pretty fair deal to me. Now, another way you can help support the work that we're doing here is with your cell phone. Yeah, your cell phone. Join us at Patriot Mobile, America's only Christian conservative wireless provider, and have your money spent not in organizations that are trying to destroy our constitutionally protected rights, but are trying to preserve those rights. Go to patriotmobile.com/constitution, find a plan that works for you. They use the same towers and networks that the major carriers do, so they've got great 4G and 5G coverage all across the country. Also look for a discount or two. Maybe you can save a little money that way. And be sure to use the code Constitution at checkout to get activation of your line absolutely free. Again, wouldn't it be nice to pay your cell phone bill and know that part of that money is being spent to protect constitutionally protected rights? Folds of Honor, the NRA. It's why I joined Patriot Mobile years ago, and it's why I'm still one of their customers. So again, join me there. It's patriotmobile.com/constitution to find a plan. And don't forget to use that code Constitution at checkout to get free activation. I also hope you'll share this episode, share all the work that we're doing here, and also bring some friends when we get together next time for the Constitution Study.